group 4, which is na i-discuss namin is yung about sa mga cases na related sa legislative, executive, and sa judiciary. So, na-discuss naman ng other groups kung ano ibig sabihin ng tatlong branches ng government at yung paano yung functions nila. So, ito, i-discuss namin kung ano yung kaugnayan ng legislative, ng executive, tsaka judiciary sa mga bawat kaso. At siguro, malalaman din natin kung ano ang purpose nito. So, yung unang kaso is Garcia versus Commission on Elections and Sangguniang Bayan ng Morong, Bataan. Yung si Enrique T. Garcia, siya yung nagsiserve at siya yung pinangalanan dito at marami siyang kasaman as petitioners. Tapos yung Commission on Elections, sila naman yung respondents dito, which is yung mga petitioners, nag-file sila ng petition sa Sangguniang Kabataan para i-annul or gawing invalid yung pambayang kapasyahan, Blag 10 sa year ng 1993. Maraming tawag dito, nilalaman yung petition nila na yon na merong kaugnayan sa kalikasan at sa kung paano magpa-process yon. Isang halimbawa na lang din sa petition, magbibigay ako kasi magbabanggit lang ako ng kahit dalawa or isa kasi ang daming nilalaman doon. Yung una is ihulay ang Grande Island sa SSEZ at ibalik ito sa Bataan. Ang SSEZ is ibig sabihin ng SSEZ ay Subic Special Economic Zone. Yun yung ibig sabihin nun. Tapos basta related siya sa iba't ibang environment tsaka sa mga ganun. Basta ganun yung about yung petition nila. Tapos, syempre, yung municipality ng Morong hindi nag-take ng action doon sa binigay na petition. Kasi di ba pagka hindi napapansin, parang within 30 days after the submission, parang mababaliwala. Pero yung petitioner resort to their power of initiative under the Local Government Code of 1991. Nagsimula sila magkaroon ng solicit na nagre-require ng bilang ng mga asignatura para sa repeal sa nasabing resolution. Tapos yung honorable vice mayor nila is sa presiding officer ng Sangguniang Bayan ng Morong, nagsulat ng letter para sa executive director ng COMELEC na nagre-request na i-deny yung petition ng local petitioners. Parang ang sabi is na nagpa-promote ng divisiveness tsaka ng productivity and ng utility. Divisive, parang nagkakaroon ng sagabal or hindrance yung petition nila doon sa nasabing siguro tatayuan ng proyekto or what. Siyempre, ang daming diniscuss about doon. Ang daming proceedings, ganyan. Pero ang main point dito is paano siya na i-ognay sa legislative. Kasi, diba, alam naman natin na yung legislative sila yung tagapaggawa ng batas, ganyan, nasa kanila sila gumagawa ng bill para maging law, ganyan. Tapos pero dun sa kaso na to, Garcia versus COMELEC, parang sabi ng mga tagapaggawa ng ating ng ating batas or nung 1987 Consti na na-realize nila yung value ng initiative and referendum, which is naging ultimate weapon ng mga tao or ng individual sa isang lugar para ma-invalidate or ma-nullify yung wrongdoings or yung transgression ng mga government officials at mabigay sa kanila yung comprehensive system. So, ayun nga, di ba nasabi ko kanina na the people were given the power to amend the Constitution itself. It is according to Section 2 of Article 17, parang it provides amendments to this Constitution may likewise be directly proposed by the people through initiative upon a petition of at least 12% of total number of registered voters, of which every legislative district must be represented by at least 3% to registered voters therein. Through that initiative, people were also have the power to enact or reject any law by the Congress or local legislative body. This according to Section 1 and Section 2 of Article 6. Yung Section 1, legislative power shall be vested in Congress of the Philippines, which shall consist of a Senate and a House Representative, except the extent reserved to the people by the provision of initiative and referendum. Tapos yung sa Section 32 naman is the Congress shall as early as possible provide for a system of initiative and referendum and the exemptions therefrom whereby the people can directly propose and enact laws as approve or reject any actor, law, or part thereof passed by the Congress or local legislative body after the registration of petition, therefore signed by at least, yun nga yung nabanggit ko, binasa ko lang ang haba niya. So, ayun. Tapos, yung iba pang details about dito is, i-report pa ng
Good morning to all of you. My name is Hazel L. Servallos from BOPS 23. Kami po ang last na magre-report. Sa amin po ay Case Digest. Isasalaysay ko lang po yung nangyari dun sa kaso at explain ko na din po. Ang akin po ay Garcia versus Commission Election SCRA 272 and 237. So, gusto ko lang po muna sa kasong ito, ang naging issue dito ay Pambayang Kapasyan BLG 10 Serye 1993 of the Sangguniang Bayan of Morong, the proper subject of an initiative. Whether or not the power initiative can be exercised, even what question is on resolution is not ordinance. Yun po ang naging issue dito sa kaso. And nag-file po ng petition ay si Garcia. Held petition is granted and Comelec Resolution 93-1623 are annulled and set aside. Then, proceed na po tayo. Sa Pambayang Kapasyan BLG 10 Series 1993, the Sangguniang Bayan of Morong which agreed the inclusion na mabilong po ang municipality as a part of SSEZ. Ang ibig sabihin po nito ay Special Economic Zone in accord with RA number 7227, otherwise known as a base Conversion Development Act. Tapos noong May 24 po 1993, petitioner filed a petition annulled Pambayang Kapasyan BLG 10 Serye no 1993. Sabi po doon na ipawalang bisa muna yung Pambayang Kapasyan BLG 10 Serye kasi may mga condition pa sila na kailangan ma-complied bago ma-include yung municipality sa SSEZ. Then Ang nangyari po nito, yung Municipality of Morong, hindi po sila gumawa ng action within 30 days after submission, which prompted the petitioner resorted the power po sa initiative under sa Local Government Code 1991, whereby dito po nag-started yung solicit required number of signature to cause the repeal and the resolution. Ang nangyari po nun, si Alberto M. De Leon as a Vice Mayor at saka Presiding Officer ng Sangguniang Bayan, siya po ay gumawa ng letter for Executive Director sa COMELEC requesting the petition for local initiative. It was be promote the divineness, counterproductive, and pulpiti po. Siya po yung gumawa ng letter para sa Executive Director sa COMELEC. Tapos po noong July 6, 1993 po, yung COMELEC naman NBank, diyan po na-resolve yung denial petition for local initiative on the ground that is subject is merely resolution po. Hindi po siya ordinance. Ito po ay merely resolution. Then yung July 13 po, 1993, further na-resolve po yung case to Director Provincial Election Supervisor Attorney Benjamin Casiano. Siya po yung nag-hold nito to authentication of signature being granted of the power by the petitioner po. So anong nangyari sa kaso po ay na-resolve naman po yung problema nila by Attorney Benjamin Casiano to hold the authentication po of signature. Then yung July 13 po, 1993, further na-resolve po yung case to Director Provincial Election Supervisor Attorney Benjamin Casiano. Siya po yung nag-hold nito to authentication of signature being granted of the power by the petitioner po. So anong nangyari sa kaso po ay na-resolve naman po yung problema nila by Attorney Benjamin Casiano to hold the authentication po of signature. Siya yung humawak nito at siya po yung nagbigay pansin sa naging problema. Then the Republican system po, there are two kinds of legislative power. Nakapasama po dito sa case na to. Original tsaka derivative. Ang ibig po sabihin ng original ay possessed by sovereign Filipino, while derivative, the elected, the sovereign Filipino, ay the sovereign people to legislative bodies and is subordinate to original power of the people. So bakit nga ba ito napasama sa Article 6? Kasi ito yung umiikot kasi dito yung initiative at referendum, and yung kasong ito ay resolution lang, hindi siya ordinance. Then bakit na-resolve to yung kaso? Kasi gumawa si Attorney Benjamin Casiano ng action at siya rin ang nag-hold ng case na ito, at may mga document at mga papel na pinakita rin sa case na to. Then gusto ko lang din i-addition is one of the lessons the people learn in the pulpit of completely surrendering to the power to make laws to the legislature. Thus, in the new constitution po is a system of people initiative was thus installed, which endorsed by the people with the power to enact or reject any act or law by the Congress of local initiative body po. While sa COMELEC naman, ang COMELEC was also in power to enforce and administer of law and regulation relative to conduct the initiative and referendum. Yun na nga po sinasabi ko kanina. Ito ay noong August 4, 1989 is approved of RA number 6735 entitled An Act Providing for a System for Initiative and Referendum Appropriating. So, yan lang po.
Yun. So, dahil nga yung petitioners ay nagsulong ng petisyon ng People Initiative under the Local Government Code of 1991, Sangguniang Bayan. Ano ba yung Sangguniang Bayan? Sangguniang Bayan is a municipal council. Sila yung tinatawag na local legislative bodies. It's the local branches of the municipal government of the Philippines. It is responsible to passing an ordinance and resolution power located at Government Code passed by the Congress in 1991. Republic Act number 7160 is also known as Local Government Code 1991, ang batas na nagbibigay daan sa paglipat ng power, authority, responsibility sa ilang gampaning pampamahalaan mula sa national patungo sa local government unit. Nakastated din on Article 2, Section 25 of 1987 Philippine Constitution, the state shall ensure the autonomy of local government. The territorial and political submission shall enjoy the local autonomy. Dahil ngayon Sangguniang Bayan of Morong is did not take any action in 30 days, ngayon nag-start na yung petitioners na mangalap ng required number of voters para mag-exist yung local initiative. And the Sangguniang Bayan of Morong is wrote a letter in executive order ng COMELEC. In the first place, COMELEC opposed the petition through COMELEC Resolution number 93-1676 and 93-1623. This allowed the initiation of local initiative to annul pambansang kapasiyahan bilang serye ng 1993. Kasama din yung pagngangalap ng required number of voters ng petitioners. Iginiit ng COMELEC na under the Local Government Code of 1991 the subject is a resolution, not an ordinance. Kasi under the Local Government Code is ang pinapayagan lang doon na petition is yung ordinance at hindi kasama yung resolution. Kasi yung pambansang kapasiyahan bilang 10 serye noong 1991 is resolution, not an ordinance. Ang isa pa is ang COMELEC is nag-rely doon sa Section 120, Title 11, Book 1 of Local Government Code of 1991, which provide local initiative defined. Local initiative is a legal process whereby the registered voters of a local government unit may directly propose or enact or amend any ordinance. Ordinance, hindi nakasaad dito yung resolution. But the Congress responded to mandate the Constitution. Ano ba ang initiative and referendum sa ating Constitution? For the first time, initiative and referendum installed in our Constitution in 1987 Philippine Constitution. The framer of our 1987 Constitution realized the value of initiative and referendum as an ultimate weapon of the people para mapigilan yung sobrang paggamit ng gobyerno ng labis na kapangyarihan. Nakasaad doon sa Section 2 of Article 17 provides amendments to this Constitution may likewise be directly proposed by the people through initiative upon a petition of at least 12% of the total number of registered voters, or which every legislative district must represented by at least 3% of the registered voters therein. Likewise, through an initiative, the people were also endowed with the power to enact or reject any act or law by the Congress or legislative body. So, yun. Dito pa lang, binigyan ng kapangyarihan ng mga tao na i-oppose yung hindi nila gustong resolution or ordinance. Dito is binibigyan ng kapangyarihan ng mga tao na i-amend yung Constitution and in the required number of voters nga lang. Article 6, Section 1. The legislative power shall be vested in the Congress of the Philippines, which shall consist of a Senate and the House of Representatives, except to the extent reserved to the people by the provision on initiatives and referendum. Dito sa case is merong dalawang legislative power na nabanggit, which are derivative and original. Actually, apat siya. Meron siyang constituent and ordinary. But dito muna tayo. Derivative legislative power is that which has been delegated by the sovereign people to legislative bodies and is subordinate to the original power of the people. These kinds of power vested in the Congress. Sa original naman, legislative power is possessed by the sovereign people. Dito na papasok yung initiative and referendum. Referendum means the process in which people refer directly or any question of law passed by the Congress or legislative body for their approval or rejection. By initiative naman, that means that the authority is reserved to the people through direct participation of the electorate in lawmaking process, either national or local level. Pinagtibay pa ng Congress ang power ng initiative and referendum. On August 4, 1989, it approved Republic Act No. 6735, entitled An Act Providing for a System of Initiative and Referendum and Appropriating Funds. Therefore, Republic Act No. 6735, the requirements for the exercise of the power of initiative and referendum. Ano ba nakapaloob sa Republic Act 6735? The Initiative and Referendum Act. Section 2 is Statement of Policy. The power of the people under a system of initiative and referendum to directly propose, enact, approve, or reject in whole or part the Constitution, laws, ordinance, or resolution passed by any legislative body upon a compliance with the requirements of this act is hereby affirmed, recognized, and guaranteed. Section 3 naman, initiative is the power of the people to propose amendments to the Constitution or the proposed or enact legislation through an election called for the purpose. There are three initiative system, which are initiative on the Constitution, which refers to a petition proposing amendments to the Constitution. The second one is initiative on statutes, which refers to a petition in national legislation. And the third one is initiative and local legislation, which refers to a petition proposing to enact a regional, provincial, city, municipal, or barangay law, resolution, or ordinance. Dito pa lang is yung mula national hanggang barangay is nag-exist yung initiative and referendum. Our Constitution clearly include not only an ordinance but resolution as appropriate subject of a local initiative. The Sangguniang Bayan Resolution being an act to the aforementioned of the local legislative as a proper subject of initiative. Nakasaad din dun sa Article 6, Section 32, the Congress shall as early as possible provide for a system of initiative and referendum, and exception therefrom, whereby the people can be directly proposed and enact laws or approve or reject any act or law or part thereof passed by the Congress or local legislative body. After the registration of a petition, therefrom signed by at least 10% of the total number of registered voters, of which every legislative district must be represented by at least 3% of the registered voters thereof. Yun, whether the Pambayang Kapasyahan bilang serye of 1993 is a resolution or ordinance, but it was covered by our 1987 Constitution and a firm of Republic Act 6735. The petition is granted. And the COMELEC Resolution 93-1623 dated noong July 6, 1993 and Resolution number 93-1676 dated on July 30, 1993 are annulled and set aside at no cost. The 1987 Constitution is born of the conviction that people power can be trusted to check the excess of our government. One of the means by which people power can be exercised is through initiative, where local ordinance and resolution can be enacted or repealed. An effort to trivialize the effectiveness of the people initiative ought to be rejected.
This is sample case digest of Executive Department. Republic versus Sandigan Bayan. GR number 152154 on July 15, 2009. Republic of the Philippines versus Honorable Sandigan Bayan, Special 1st Division, Ferdinand E. Marcos, represented by his estate and heirs Imelda R. Marcos, Marcos Monotok, Ferdinand R. Marcos Jr. Republic filed a petition for the Sandigan Bayan in the declaration of aggregate amount of $356 million deposited in the PNB. In addition, the Republic sought the forfeiture of $25 million and $5 million in treasury notes, which exceeded the Marcos couple's salaries, other lawful income, as well as income from legitimately acquired property. The treasury notes are frozen at the Central Bank of the Philippines, now Bangko Sentral ng Pilipinas, by the virtue of freeze order issued by the PCGG. General agreement sought to identify, collate, cost the inventory of the distribute all assets presumed to be owned by the Marcos family under the conditions contained therein. The general agreement specified in one of its premises or were clauses the fact that petitioner obtained a judgment from the Swiss Federal Tribunal on December 21, 1990, that the $356 million belongs in principle to the Republic of the Philippines, provided certain conditionalities are met. RA 1379 raises the prima facie presumption that a property is unlawfully acquired, hence subject to forfeiture. Its amount or value is manifestly disproportionate to the official salary and other lawful income of the public officer who owns it. Public was able to establish prima facie case for the forfeiture of the Swiss funds pursuant to RA 1379. 1. Ferdinand and Imelda Marcos were public officers. 2. Ferdinand and Imelda Marcos had acquired and owned properties during their term of office, as evidenced by their admittance regarding the ownership of Swiss accounts. The Swiss accounts of the Marcos had balances amounting to $356 million, a figure beyond aggregate legitimate income of $304 million and $372. So, pinakasami rin nung case ay susunod na grupo. Tapos, ipapaliwanag ko muna yung mga ginamit na law term. Katulad ng prima facie. Prima facie is a legal claim that has sufficient evidence to proceed to trial or judgment. 2. Certiorari is a court process to seek judicial review of a decision of a law court or the government agency. Forfeiture is the loss of any property without compensation as a result of this defaulting on contractual obligations or as a penalty for illegal conduct.
For our conclusion, On December 17, 1991, Petitioner Republic, through the Presidential Commission on Good Government or PCGG, represented by Office of the Solicitor, filed a petition for forfeiture. Petitioner declared that the aggregate amount of $356 million, estimated now to be $658 million, deposited in the escrow account in the PNB is declared as ill-gotten wealth. Supreme Court ruling noong July 15, 2003 is that ang pera ng mga Marcos ay sobra or labis compared sa kanilang salaries. Ito ang legitimate income ng mga Marcos noong 1965 to 1985. Their salary is 2.6 million. Ang salary ni President Marcos is 60,000 per year, and ito ang pinaghalong salary ni Imelda at ni Ferdinand Marcos. Sweldo ni Imelda Marcos as Minister of Human Settlements. And yung law practice na 11.1 million, which is hindi pwedeng mag-practice ng law ang isang president. And farm income na 0.14 million, and others naman is 2.5 million, total of 16 million. And sabi ng Supreme Court is the money is unlawfully acquired, and if the wealth of an official is parang sobra compared sa kanilang salary, it is an ill-gotten wealth. So, if ang wealth ng ni Marcos ay declared as ill-gotten wealth, bakit hindi sila nakukulong? Ito po ang dahilan. Ang habol lamang po ng government ay civil forfeiture case, dahil hindi nila pwedeng habulin si Marcos na criminal case because he died on September 19, 1989. So in conclusion, there is no issue of facts which calls for the representation of the evidence. The motion for summary judgment is hereby granted. In summary, the evidence offered for the judgment of the case did not prove that the money in the Swiss banks belonged to the Marcos spouses, because walang legal proof na nag-exist in the record na nagsasabi na sa kanilang ownership ng mga Marcos doon sa bank account.
So, ngayon pupunta tayo sa hatol kung bakit granted ang desisyon ng korte sa kaso ni Marcos. So, ang sabi dito is the failure to present authenticated translations of the Swiss decisions. So, based sa petition, the petition is hereby granted. The assailed resolution of the Sandigan Bayan dated January 31, 2002 is set aside. So, the Swiss deposits which were transferred to and are now deposited in escrow at the Philippine National Bank in the estimated aggregate amount of $68,175,373 as of January 31, 2002, plus yung mga interest pa dun sa pera na yun. So, are hereby forfeited in favor of petitioner, the Republic of the Philippines. So, in terms naman sa sa question, bakit hindi po sila nakukulong, yung mga Marcoses po. So, si Ferdinand Marcos to be specifically. So, kung sa decision ng Korte Suprema natin ay merong ill-gotten wealth ang mga Marcoses, bakit po sila hindi nakukulong? So, simple lang po. Ang civil forfeiture case na lang po ang habol ng gobyerno, dahil hindi na nila pwedeng habulin si Ferdinand Marcos ng criminal case kasi namatay na siya noong pang 1989. So, additional, ano nga ba pag sinabi natin ill-gotten wealth? Okay, ang paalala ng Korte Suprema ay may nagsasaad na kung labis-labis ang kayamanan ng isang opisyal kumpara sa kanyang lehitimong sweldo, ito ay itinuturing na ill-gotten wealth or nakaw na yaman.
Hi guys! So, let's move forward to Article 8. Ang Article 8 ay Judiciary Department. So, nandito si Gezel para i-explain sa inyo kung ano nga ba ang meron sa Judiciary Department.
Ang Judicial Department. Ang Judicial Department ay mayroong judicial power. Dalawa lang yan. Una is to settle actual controversies. Meron talagang mga legal issue na demandable, enforceable sa pagitan ng dalawa, tatlo o higit pang mga partido. Yes, we are all free but we are all bounded by the law. Since we are all bounded by the law, we are also protected by it. Ang pangalawa nilang kapangyarihan is to determine grave abuse of discretion. So dito, meron silang karapatan na tingnan, alamin, siyasatin ng isang tao o iba pang mga departamento ng gobyerno kung sila ay nagmamalabis sa kanilang kapangyarihan. At kung matatandaan natin, ito lang ang department na mayroong check and balance. Ang kaso ay belong sa Article 8 dahil ang kaso ay mayroong issue na committed grave abuse of discretion na kung saan ang petitioner, ang kanyang allegation ay nagkaroon daw ng pagmamalabis sa kapangyarihan ang mga teacher kung kaya't nagresulta ito ng inequality. Ang pinag-uusapan sa kaso ay kung nagmalabis ba ang mga teachers sa kanilang kapangyarihan. So, yung pinag-uusapan sa kaso ay isa yon sa mga kapangyarihan ng Judicial Department, which is to determine grave abuse of discretion. Kaya, obviously, yung kaso is belong sa Article 8.
So, in this case digest, I am assigned to summarize the whole case. So, let's start. The petitioner was a grade 6 student at Serra Elementary School in Cotabato City. School year was about to end, so the committee that was assigned to rank the students gave their list of its graduating class. Chodoro was third honor. He was a consistent honor student, while Lingyat, second honor, has never been close to him. Chodoro Santiago Jr. filed a petition because he cannot accept that Lingyan comes second honor than him. He sought for any invalidation that the committee on the rating of students did. He also stated that there were circumstances that the committee discriminate him to pull him down. The petition was dismissed because of judicial function cannot be exercised in this case. Let us hear from Donna why this case was dismissed.
Petitioner filed a petition of certiorari. The issue of this case is whether or not the judicial function can be exercised in this case. Unfortunately, the petition was dismissed because judicial function cannot be exercised dito sa kaso. Ang certiorari ay isang special civil action na itinatag against any tribunal, board, or officers na nag-exercise ng judicial functions. So in judicial functions, it is an act performed by virtue of judicial powers. In order that certiorari may be invoked, kailangan nag-exist muna yung mga sumusunod. So una, there must be specific controversy involving rights of a persons or property. At yung nasabing controversy is brought before the tribunal, board or officer para sa hearing or determination ng kanilang respective rights at kanilang obligations. Pangalawa, the tribunal, board or officers na kung saan dinala yung controversy must have the power and authority to pronounce judgment at makapagbigay ng desisyon patungkol dun sa controversy na yun or issues. At pangatlo, the tribunal, board, or officers must pertain to that branch of the sovereign power na belong lang sa judiciary at hindi belong sa legislative at sa executive department. So, only the judiciary lang. So, as the case is stated, hindi nasunod ang alinman sa tatlong nabanggit. Bukod doon, na-violate din ang mga sumusunod. So, the petition does not comply with the second paragraph of Rule 65, Section 1, which stated that the petition shall be accompanied by a certified true copy of the judgment or order subject thereof, together with the copies of all pleadings and documents relevant doon sa mismong kaso. So, yung petition na yun ay may kasama dapat na certified true copy. Katulad nga ng nabanggit, kailangan kasama din doon yung mga pleadings and documents na relevant doon. Bukod doon, sinabi ng petitioner or the petitioner stated that he received a copy of program ng kanilang graduation. So doon makikita at doon may papakita yung decision ng Committee of Teachers tungkol sa ranking ng honor students. But then, he could not attach it into his petition. So, this decision ng committee about sa ranking of honor students ay alam niya na before pa siya lumapit or mag-file ng petition sa korte. Bukod dun sa mga nabanggit ni petitioner, nabanggit din ni petitioner ang mga sumusunod on how the committee violated the rules of service manual for teachers. So, yung na-violate doon, yung committee kasi dapat, according doon sa service manual for teachers, yung committee dapat napipili ng mga ranking students ay kailangan nagko-compose ng grade 5 and grade 6 na teachers. Pero doon sa school ni petitioner is only the grade 6 teachers lang. Maging na-alter din yung kanya mga grading sheets or yung nabago yung mga grado niya at yung maging nagkaroon din ng erasure sa kanyang grade 1 certificate. Knowing all of those, the petitioner never bothered to attach this sa kanyang petition. So, sa kabila ng pagkakaalam niya sa lahat ng mga facts na yon, ay hindi niya yun na-attach doon sa kanyang petition. Bukod doon, aside from that, the administrative remedies neglected. So, nakalimutan din. So, yung tinatawag na administrative remedies doon is the Department of Education. Siyempre, since the teachers and the students yung involved, nagkaroon ng dispute between them, siyempre, ang una dapat makakaalam doon is the Department of Education. But then, siguro na pressure si petitioner, kaya lumapit agad siya doon or nagsampa agad siya ng kaso laban doon. So, na-neglect yung pinaka-administrative remedy na tinatawag. Pwede kasi, di ba, na maimbestigahan ng Department of Education at sila yung magbibigay ng effective remedy para doon. But then, ganun nga yung nangyari. So, nagkaroon ng administrative remedies neglected. It is evident upon the foregoing authorities that the so-called committee o yung tinatawag na committee doon sa pinag-uusapan dito sa kaso, Committee on the Rating of Honor Students kung na tinatawag, whose action or question dito sa kaso, exercise neither judicial nor quasi-judicial function. So, hindi niya na-exercise ang judicial or maging ang quasi-judicial functions. So, by stating all of these, the petition of the certiorari is being dismissed by the court.